This is the Lady Lawyer League podcast, Omaha's leading lady lawyers, empowering women to be legal savvy. Hosted by Susan Reff and Tracy Hightower of Hightower Reff Law.
Welcome to the Lady Lawyer League podcast. I'm really excited to have Tosha Heavican on today. She's not really a guest because she's a partner attorney here, and you're going to hear her with me a lot on the podcast.
That's
so,
exciting. Yeah.
I know.
Thanks for having me today.
So welcome across the hall from your office. You didn't have to travel very far.
That is an excellent, awesome fact in my life that I didn't have to go very far.
Tosha's office typically always has really good snacks. And right now it's the dark chocolate Reese's peanut butter cups, but not Reese's brand.
Correct. They're from Trader Joe's. And people, I don't even buy them myself. People actually give me them as gifts because then they can come and have them when they need them.
But she hides them in a drawer.
Yeah, because otherwise I would eat the whole container. So I have to like trick my mind that I don't actually have them until then I remember.
But then everyone just comes in your drawers when you're not there.
Well, I got nothing to hide.
Yeah.
I also have a really fun like couch situation in my office too. So people come and
it's not a couch.
It's a Shea lounge.
Right. Also known as something else in our office, but we won't go there. Also, we can cuss on the podcast. I've been asked that question.
Oh,
if you
okay,
want to.
good.
Not that the chair has anything to do with cussing, but
right.
I don't know. But it's not a couch.
It's a Shea lounge.
Yeah, you're right. Well, that's a little bit about Tosha. So today we're going to talk about a podcast that we've talked about before, but it's really important to talk about as many times as we can.
Absolutely.
Specifically, what are the 4 must-have estate planning documents? So we're going to talk about that. And also how Tosha does estate planning in our office and how important she finds it in our world for all types of people, not just people with a whole bunch of money.
Exactly. One of our sort of mottos or mantras in our office is that estate planning is for everyone. And so much about estate planning really doesn't have anything to do with how much money you have in your bank account, and really so much about what you want to have happen and who you want in your corner if something bad were to happen and somebody has to step up and help take care of you.
You know what I often think about too is sometimes people are like, well, I don't really care because I'll be dead. But so much of estate planning happens before you die.
When you're alive. Exactly.
Yeah, when you need someone to maybe go in and pay your bills because you're in a coma because you got in a car accident, which no one plans.
Exactly.
Yeah. But then I always remember what you say, and I say this to people all the time, is you don't need to have an estate to have an estate plan.
Exactly.
We should call it something else. A life plan.
Life plan.
Get your shit together plan.
There you go.
Yeah.
I like it.
We don't need to have an estate. And then also for people like me that don't have kids, I sometimes, and I went for a long time without having a will, like I don't need one. But I really need one because no one's going to know where my shit goes after I die.
Well, and especially if you don't have a will, then really you're relying on the state legislature to decide where your stuff goes.
We do not want to rely on them, y'all. Let me tell you.
And I know enough about you to know, for example, that you are very philanthropic. You're very charitable. The legislature, the statute that passes out your assets, if you don't have a will, doesn't have anything in it about charity.
Right.
So there's so many opportunities to do things with your estate that the statute really doesn't contemplate. And so being able to have a plan that's tailored to you is really an awesome feeling, especially because you know it's a life you've built. You should be able to control what happens to it when you're not with us anymore.
Right. Or in a coma or whatever.
Exactly.
Yeah. Okay. So it's probably been 4-ish years since we've talked about estate planning on our podcast. So maybe tell us what things maybe have changed in estate planning world, and then we'll talk about those 4 really important documents. What has the legislature been doing to us?
Well, in terms of estate planning, there actually was one positive development that's happened in the last few years, and that is, it's a negative and a positive. In Nebraska, we're one of a few states that still has an inheritance tax. So when you die, your estate has to pay a tax, or the beneficiaries pay a tax on what they receive from you. And the amount that you pay depends on, 1, how much you receive, and 2, your relationship to the person who died, whether you're a child or a nephew or a friend. And the good thing that has occurred is that in the last few years, the legislature actually passed a law to increase the exemption amount. So you get more money that's non-taxable. And for 2 of the beneficiary levels, they reduced the percentage. So they pay less amount on less money.
They're taking in less taxes?
Yes.
No way.
Yes way.
And sometimes that really, really affects a lot of our Nebraskans, like farmers and people who have a lot more taxable assets. Is that true?
Yes, there's definitely an emphasis put on real estate. And I say that because when a tax is not paid, the county attorney is able to put a lien on real property, which is what I call dirt, right? So a house or a farm ground. And then if that tax isn't paid within a year, the county can start assessing penalties and interest on that land.
And one of the things that we do in our office, amongst our 10 lawyers, is somehow we have one or more lawyers involved in things that are happening in the legislature. Like I'm on the legislative committee of the Bar Association. You are also part of that group. And you are part of the real estate,
probate, and trust section.
Yeah, that section. So we have different sections of the bar that lawyers have a lot of input on crafting laws. Imagine that. And so we do stay on top of a lot of things that are happening in Nebraska and Iowa, because you're also licensed in Iowa as well.
I am.
Secret, she lives in Iowa. She likes to maybe not always tell people that.
I don't mind. I'm still a Husker, so.
Yeah.
I just pay less in property taxes.
True. You do. Okay, so let's talk about the 4 must-have estate planning documents. What are they, first of all? What are the 4?
So when we are alive, we want to make sure that we have in place a power of attorney for finances, a power of attorney for healthcare, and then sort of in conjunction with that is this idea of a living will, which we'll get into and talk about. And then once you have passed away, the document we want to make sure you have is a last will and testament.
But write it before you pass away.
Exactly.
Right. Okay.
The ship has sort of sailed if you are dead.
And one of the things that we talk about that I see a lot, I do mostly divorces in our office, and obviously there's an overlap between divorce and estate planning, because usually when you get divorced, you should get a new will, spoiler alert, or write a new will or write one because you never had one. And I see from my client's perspective, which is a very small microcosm of people doing estate planning, there's a lot of delay in doing it, both having the discussion and then actually signing it.
Yes.
Would you have insight to that?
I think it's sort of a combination of different factors. One is sort of this idea of, people don't like to think about death, right? And sometimes we think we're infallible, or we think that, that sort of weird situation is never going to happen to me.
Because I've had clients that literally will say, if I come in and sign that, I'm like going to say I'm dying and then I'm going to die. Literally, people have very interesting thoughts about signing estate planning. But we have seen in our office the actual stories of what happens when you don't have these documents, when you don't have a power of attorney, which is like a 1.5-page document.
Power of attorney is, mine are like 6 or 7 pages.
Okay. Well, super simple though, right?
Yes.
But so important, because this is what's happening while you're in that so-called coma. And
Right.
then what are you going to wake up to? A mess or not?
Right. And I think so much of it is also part of the estate planning process is not so much, part of it's what's in the document, but also more importantly, who are you choosing, right? And having that conversation with your spouse, if you have one, your kids, if you have them, your parent, whoever it is, to say, okay, if we're in a situation where you can't tell us what you want, you can't tell us what you need, who's going to be the person that steps up and says, this is what should happen? And, I jokingly tell clients, like, don't pick the kid that sucks. Don't pick the kid that is not in the group text.
Yeah.
Right?
Just because they're the oldest, don't
Right.
pick them.
Right. Like, you need to pick the person that is going to, one, do what your wishes are, but two, be able to sort of navigate the family dynamics, right? And that's such a part of it. And being a power of attorney for somebody, it's kind of a thankless job. It's not like people are lining up around the block to be that person.
Right.
Right.
Sometimes you do it without getting paid too.
Exactly.
And it's a sad thing too. Someone maybe is dying or is in a really hard place or has died. And now you are sort of picking up the pieces. If you're an executor.
Yes.
Yeah.
It has like different names depending on what state you're in, but it's pretty much the same job.
Yeah. Okay, so let's talk about last will and testament first.
Sure.
So tell us in general what that means. Why do we have two words? Why is it will and testament? Do we always capitalize the W in will? Those are the questions I always have. Some of them don't matter. Okay.
I always capitalize the W on will because I feel like it's like an important document.
Right.
It's called last will and testament. You're going to love this answer because that's what we've always called it.
Right.
So, which I suppose is a good reason as any in this circumstance. So a will, let me say that again. A will controls probate assets, which sounds like very, terminology laden. But really what that means is that it only controls something that is in your name only that you have not put a beneficiary on. So if you have a bank account, for example, that's in joint tenancy with your child, your will doesn't control who gets that. The child gets it because their name is already on it. And so that's one of the things that we talk about a lot with clients is titling. So a will controls those assets that are just in your name, and you get to say where they go. It's also going to be able to have you name a personal representative or executor for your estate. So the person who's actually going to collect the assets, pay your debts, handle your funeral, those types of things. I typically will put wishes for like funeral, burial, cremation, those types of things in there. Also, if you are a person who has minor children, the statutes in Nebraska allow you to name a guardian for your children, and that person sort of goes to the front of the line in terms of who can be the guardian for your kids if you no longer can.
Okay. So these are the things that you talked about that are really important to name the people that don't suck.
Right.
Yeah.
Right.
And it doesn't have to be your kids that you name your adult children. And people don't need to know who you name. Right?
Exactly.
And sometimes it's a surprise to some people after you die, like, whoa, they named that person. I didn't see that one coming.
Right. Right.
And that's kind of fun. And you can also change it, right? Throughout your life. If someone didn't suck at one point and now they suck and you want to take them off as the personal representative, then you get in there and take them off.
Exactly.
Yeah.
Exactly. Nothing in a will is written in stone. I always say it's written in sand. So if you need to make changes in the future, we always can.
We're not carving them on a tablet.
Right. Right. With my laser.
Yeah. Or you're just your like tablet carver. Like how you make guacamole and no, okay.
No.
We're not doing it that way. We're actually doing it in a legal way. But anyways, you can change it at any point. And I think that's really important. And also one thing I was going to say earlier is, you and your spouse may come in and do a will together and you're sort of on the same page that like this person's going to take care of our kids. Or this person's going to be your PR and my PR as husband and wife. You may come in and be like, I didn't really want that and I can change mine and not tell my husband, right? Even if you're not divorcing, you can come in and say, I really don't want my husband's friend John to be the PR. I want my friend to be my PR.
Right. And I think, so for us as attorneys, when we represent couples, we can do that and have those conversations as long as they're on the same page.
Right.
If, let's say, a husband and wife come in and then, a month later, husband calls me and says, secretly, I want to do this other thing, we can't represent them. They would have to go to a different attorney. But the idea that your will is your own is 100% accurate. years ago, probably before you and I were even born, they used to have where it was like the will of the couple, and of course it was under the man's name.
Of course.
Right. All of those things.
The woman didn't even sign it.
Right.
Yeah.
And so, interestingly, I've had clients, obviously of an older generation, but ask me like, don't we just have one will, or like, it's always interesting to me, sort of that idea that this couple can, like, you're not independent of each other.
You're like, we are not in the Handmaid's Tale movie, so no.
Right, exactly. Each person has their own will.
Okay, and we're going to do a whole other episode on what happens with estate planning after divorce, because I think we can talk about the importance of that in a whole episode. But just, we have clients, of course, that just come in to do estate planning that have nothing to do with divorce, right?
Right.
And that's what you do, because you don't do divorces, and you've made that very clear.
Extremely clear. Yes.
Okay, so the powers of attorney, tell us a little bit more about the financial power of attorney and the healthcare power of attorney. Why do we need both of them? Can we just do one of them? And also tell us, because I think these two documents are really actually very simple documents, and can people just find one on Google and do it online? And why or why not should they do that?
Sure. So power of attorney documents are some of the most important documents that I do. And again, they have nothing to do with how much money you have, and so much to do with who's going to be making decisions for you. So let's start with power of attorney for healthcare. So this document under the statute allows you to pick one person at a time to make healthcare decisions for you if you cannot make them for yourself.
So this is are we pulling the plug or not?
Right. And that's what people always think of, right? Like the Terry Schiavo case, right? From, was that Florida? I think it was Florida. But it's also like, what's more common is the day-to-day stuff where dad has dementia, and now we have to figure out what care home is he going to go to? What doctors will he see? Access to his medical records. What treatments are you going to provide him? Do we have him on this med or that med? Those types of decisions, right?
And in this example where dad has dementia, dad has signed this power of attorney before he had dementia.
Correct.
And that is the most important thing.
Correct.
And I think we always constantly think about that, because we see adult children coming in saying, my mom has dementia, but she hasn't signed a power of attorney. And you're like, too late.
Correct.
So every once in a while we can still like communicate with the doctor and ask if they have moments of.
Yeah. Capacity is fluid, right? I mean, and we, you've heard of, for example, like sundowners, where a lot of times certain individuals do better in the morning, and then in the evenings, they sort of have more diminished capacity. And so, the earlier, the better in these types of situations, because there does come a point where the person can no longer sign documents. And then at that point, our only recourse is to file in court. And that's sort of the main benefit to powers of attorney, is that with them, you can avoid guardianship and conservatorship in the court process.
You can avoid hiring an attorney during this really traumatic time that you need to make decisions for someone that can't make their own decisions, paying the attorney, going to court, probably literally having to go in front of the judge, and then also waiting for the court hearing.
Yes. And
then hoping the judge grants what you want.
And the amount of paperwork that you have to do to become a guardian, you have to take a class, you have to do background checks. It is somewhat of an onerous process, and not necessarily, rightfully so, right? When you are becoming someone's guardian, you are taking away their autonomy, their ability to make decisions for themselves. So the court doesn't take it lightly, and they shouldn't. But in a situation where a person truly needs a decision maker, that lag in time can be difficult for families.
And for doctors and medical providers.
Absolutely.
Yeah.
And so by having this power of attorney in place, once it's invoked, then that person can just sort of step right in and start making decisions to help, their loved one.
I always just picture in a moment where like a decision needs to be made, someone's like slapping the power of attorney on the table, like, it's me, move aside, and I'm making the decisions. That's what I always picture.
Yeah. Yeah.
And, I'm my parents' power of attorney, or I don't know exactly if I'm like successor or whatever, but I always think like I need to have this paperwork in my hand at all times. I'm going to slap it on the table. And I think my dad's like, my doctor's got it in the file. Like, you don't need to carry it around with you.
Yeah. Probably because his really good lawyer told him that that's where he should put it.
Yes. Spoiler alert, Tasha's my dad's lawyer for estate planning.
I always tell this funny story when I give talks about estate planning because of course I did my husband and I's estate plan. And so I'm talking to him and I'm saying, okay, we have to do this healthcare power of attorney. And so who would you want to be your agent if I couldn't do it? And he's like, well, I mean, I don't know if I would pick you first.
Oh.
And I said, what? And he was like, well, I just would think like if I was, in a coma or dying or something, like you would be really distraught. And so I think, maybe I would have my brother be first. And I looked at him and I said, I think maybe you need a new lawyer.
Maybe your brother's distraught too.
Well, I tell people all the time, you don't have to choose your spouse unless you are Cole Heavican.
Cole, I'm coming at you. Okay, financial power of attorney. So tell us how that's different than the healthcare power of attorney.
So within sort of this idea of financial power of attorney, there are two kinds that I typically talk to clients about. So one is going to be similar to the healthcare power of attorney where it is springing, right? So you make your own financial decisions so long as you are competent. And then if a doctor says, okay, you're no longer competent, then this document sort of springs into action and the person can step in and do things for you. The alternative that's pretty common is just a general durable power of attorney where as soon as you sign it, the person you have appointed can make decisions for you financially with or without your permission or knowledge. Okay. So, and this avoids the need for a conservator. So similar, court proceeding for a guardian conservator. So the person is able to step in and do things like apply for benefits if you need Medicaid or Social Security or Medicare or things like that. They would be able to sell real estate for you. They'd be able to...
they go into the bank and slap that power of attorney on the table and say, give me all their money.
Exactly.
Which is also really important, right? Because the healthcare power of attorney is literal life and death decisions. Court doesn't take it lightly if you don't have a power of attorney and who they might appoint. And then we also have financial power of attorney because they literally take over your debts and assets.
Right.
And the court, if you don't have that in place, the court doesn't take that lightly either because you are literally able to walk into the bank and withdraw a whole bunch of money if you wanted to.
Exactly.
I mean, at some point you have to provide an accounting, right? But
correct. Once a year.
Yeah. Only once a year. You could spend a lot.
Well, yeah. And that's the reality is that if the money is gone, there are ways to ask for it back. But if it's gone,
yeah.
If the person didn't have money before, it is unlikely that they have money now to pay it back.
Right. Yeah. Okay. So those powers of attorney are really important. And the living will, the fourth document, living will or advance directive, it's the same thing, right?
So the living will deals specifically with end of life care decisions. So I typically will put language in a power of attorney for healthcare that allows the agent to make the decision to terminate treatment under certain requirements.
This is the DNR stuff.
Correct. So
stands for do not resuscitate.
Correct.
Okay.
And so typically there's going to be language in the power of attorney specifically regarding, living will language that says once a doctor has determined that you are terminal, the sort of the fancy language is unlikely to return to sapient life. Then after...
Oh my God, seriously?
Yeah.
Like the Homo sapiens?
Right. Sapient life. That after a certain time period passes, then your agent would have the ability to, not the requirement, but the ability to terminate treatment. And something sort of to know that I found interesting and have learned through my practice is that if you are an organ donor in the state of Nebraska, in order to donate, once they have determined that you are in a persistent vegetative state, for them to harvest your organs to be able to have them be viable as a donor, you have to start that process within 48 hours. So your agent basically has 48 hours to decide, okay, we're going to terminate treatment and then just see how long you live.
Can your agent decide to donate your organs if you haven't before?
I don't think so. I think you have to
It
elect
needs
that.
to be on your driver's license,
Exactly.
people.
Exactly.
And that phrase you said, a persistent vegetative state.
Correct.
That's where we get the phrase from, I don't want to be a vegetable.
Correct. Right.
See,
Basically,
we're
your brain.
linking everything here together.
Right. So it's like you're brain dead. Right.
Yeah. And you're persistently going to, you're not coming out of it.
Correct.
Yeah.
So the living will statute sort of takes it this extra step where it will say, instead of your healthcare agent making the decision to terminate treatment, the living will is almost like a letter to your doctor that says, dear doctor, if I meet these certain requirements, you are required to terminate treatment.
Mm-hmm.
So it sort of takes the decision away from your family and puts it with your treating physician.
Got it. So that's different than your healthcare power of attorney.
Correct. And so a lot of times it's just a conversation with clients about whether or not they want to go that extra step. I have had a few clients that have elected to do the living will, situations where they really just don't feel that their family would do what they want, to have the termination occur. And so because of that, they have done the living will.
And we have a lot of clients that come to us and say, well, do I need a will or a trust? And without answering the full, like, what is a trust? Because we're going to do a whole separate episode about that. What's your basic answer to that? The lawyer answer.
It depends.
It depends. But we do have, different reasons that a client may need a trust as opposed to just a basic will. And what we've talked about today really is the basic estate planning documents. And we'll talk more about what it means to have a trust later.
Exactly. Basic planning is really sort of the first step. And it's actually so important to me that we have developed here at Hightower Reff Law, we've developed an entire program, around this idea of basic planning. We call it Will Express. We have a whole page on our website about it. And
check it out, hrlawomaha.com or Will Express.
And so we have flyers and we hold it 3 to 4 times a year. And it's really sort of this idea of making estate planning accessible to everyone and in sort of a streamlined process and also at a little bit of a discount. And so we try to really make it something that is attractive to people so that they get these documents done.
And it's this idea of like, get in and get it done. We toyed around with the idea of like will in a day or will in an hour, but it's just Will Express. It's getting done fairly quickly. You are giving us all the information of what you want included in these documents. We're typing it up. We're signing it. We're not waiting around for you to decide whether you're going to die after you sign it or not, right? You're going to come in and sign it and then you leave. And so we have done these Will Express days where we have like 10 to 12 people signing their wills in one day. It's really cool.
Yeah. It's really a neat thing. And we've done it with groups too. Like, having a group of people, sort of predetermined that they want to all do this at the same time. And so then we just set aside some time and have our laptops and we get her done, as Larry the Cable Guy would say.
Someone from Iowa would say that too. Okay. When should someone talk to an attorney? Like, what's the best time to talk to an attorney about estate planning in general?
Literally any day that ends in Y.
Yeah.
Except for we're closed on the weekends.
Yeah. Yeah. I think, we've had cases where we've had 21-year-olds get into a car accident and they had no estate planning documents and they never thought about having a will. We have these instances where we have college students who are, living outside of Nebraska and their parents live in Nebraska and something happens to them and they don't have a power of attorney and something happens and no one's there to make a decision. And then if you think about, add to that, the parents are divorced and they might be fighting over who's going to be the power of attorney. And these are literal situations that we've seen with our clients. So we know when Tosha says any day that ends in Y is so true that when you become an adult, do an estate plan and have it outlined. But then my next question is, how often should you be reviewing your estate plan with your lawyer?
So my practice is that I send out a reminder letter to clients every couple of years that just says, hey, make sure the things that you have done with us are still applicable. You still, talk to the people that you've chosen. You still like those people. You want those people in those places. Have you had any big life changes? Has there been children born or grandchildren born that maybe you would want to provide for, different things like that? And if you everything's good, you don't necessarily have to call me, but if you do have questions or you want to take a second look, then let's have that appointment.
Yeah. And I think, I want to encourage listeners to check out our website. There's a ton of information on our website about estate planning. Our social media, Facebook and Instagram also has a ton of information. And then really do check out our Will Express. We have one coming up in April, and we'll probably do another one this summer. So check that out if that's something for you. It's really important to get your estate planning documents done. And, we're going to talk a lot about, I think, AI as we go through our podcast too. And it's really scary what AI can do, right? And how great it looks. But of course, we're slightly biased. But I think, speaking with an attorney, at least doing a consultation with an attorney, if you want to go use AI after that to generate documents, do what you want. But we also have seen AI generated documents later that have to be litigated because they're not appropriate. So I think that becomes really scary when people are relying too much on that. And we'll talk about that as we do more podcasts. So
exactly.
Thanks for coming across the hall and being on today. You'll see a lot more of Tosha in our podcast because she is a partner attorney here. And we're going to talk more about estate planning and what Tosha does in later episodes. Thanks for listening.
Thank you for listening to the Lady Lawyer League podcast, and be sure to like and subscribe anywhere you get your podcasts. If you would like to learn more about our firm, Hightower Reff Law, please visit our website at hrlawomaha.com.
We'll see you next week.